Let's take a walk downtown Atlanta while I explain to you how to get an attorney to pay attention to your case. Every day, employment lawyers get calls, emails, and DMs from people looking for representation. This is one area of law where the lawyers stay busy pretty much all the time because everybody has a job or at least knows somebody with a job, so it makes sense. But here's the truth. Many of the messages we receive never get a second look. And it's not because we don't care. In fact, we care very much. That's why we work in this area. But it's because of the way people present their situation. It makes it nearly impossible to see if there's actually a legal claim there. So today I'm going to tell you how to get an attorney to pay attention to your messages. Lawyers are busy, just like everyone else. So the first thing we do is scan to see whether your message contains a legal claim. But if your message is full of details that sound frustrating or irrelevant but not illegal, your email may not get past the first sentence. If you spend the first page talking about how long you've been with the company, what you do with the company, that's all well and fine, but you're probably not going to get very far. If you use catchphrases like "my boss plays favorites" without telling us why that's problematic from a legal perspective, you're again not going to get very far. You may have a case hidden in your story, but if it's buried in 5 paragraphs of emotions or things that are not illegal, we may never see it. So some common mistakes I see, again, are getting way too emotional. We want to be able to help you, but if you keep talking about just how you've been treated unfairly or how your boss shows favoritism or how you're working in a hostile or toxic work environment, again, that doesn't tell us anything. That's a lot of buzz phrases, but we don't know the details. Hostile work environment, for example, is a legal term, but it only applies if the hostility is tied to discrimination based on a protected category. And you're going to hear this time and time again. Everything comes back to protected categories: your age, race, sex, gender, disability. Everything in employment law is about comparisons. You were treated unfairly compared to what? Compared to who? So we need you to get to the details when you email us. So you should structure your story with headers. Who? Who was involved? Is it a supervisor? What's the race of your supervisor? What's the gender of your supervisor? What's the age? Whatever is relevant to your claim. Did you go to HR? Do you have coworkers who are involved? Who are those coworkers? What happened? Be specific. Did you get written up? Were there demotions, terminations, suspensions, denials of promotion? And why are you telling us about that? Why do you believe that's wrong? And then timelines. Timelines are super important when it comes to employment cases. Did you find yourself on the receiving end of some adverse action right after you complained about something so that maybe it's retaliation? Everything in employment law, again, comes back to race, sex, age, gender, disability, etc. And timelines are incredibly important because if you're complaining that you are being subjected to retaliation for a previous complaint, the first thing I want to know is, when did you complain? And when did the so-called retaliation occur? Because if you complained a year earlier, then that's not going to get you very far. So be very specific when you're writing your email about what happened to you. Keep it short and to the point. Believe me, lawyers have no problem asking you for additional information if you need that. So timing is everything, and your protected class is important, and we need to know the demographics of the person that you are complaining about also. Try to keep it down to 1 page. And again, we'll ask for more if we need it. It was interesting talking about getting an employment lawyer to take your case. We prefer working on a contingent fee basis because if we win your case, we're going to get paid a lot more money than we would if we worked on an hourly basis. So attorneys are very specific because we have to front a lot of costs. We're very specific about the details that we want from you, because we're going to be held to that same standard when we are presenting your case to court. We're going to have to show that you were treated unfairly because of your age, race, sex, and gender. And the only way to do that is to show how other people who were in a different protected class or who were not in the protected class were treated as compared to you. So when you write to us, give us those details. That's what will get us to pay attention. And if we take your case on a straight contingent fee basis, then we feel pretty good about it because, again, we're going to invest a lot of money and time in your case. And we're not going to do that if we don't think that we can win. So when you send an email, again, get straight to the point, not using buzz phrases, but telling us what your protected class is, how you were treated unfairly based on your protected class, and whether or not you have witnesses, whether you documented everything. Tell us everything you have. And I'll tell you also, one of the first things I look for is how long you've been with the company. You'd be amazed at how often people write to me after they've only been employed for 2 or 3 weeks. Courts are not going to take your case. They're not going to let your case get very far if you haven't even made it through the probationary period. I mean, there are some exceptions. There's always exceptions to pretty much everything. But that's something that a court is probably not going to look at. So I don't tend to take cases where the person has been there for almost no time because, I mean, if they wanted to not have you there, they didn't want you there, they didn't have to hire you in the first place. And I know that a court is going to say, listen, you didn't even make it through the probationary period, and they're not going to let it get very far. So I won't waste your time or mine. I hope this helps. And if there's something you'd like me to go into more detail about, you can always let me know in the comments, and I'll try to make a post addressing that. So good luck with your case. Take care.